and I'll invite Mr. Siegel to resume his submissions.
I'm grateful, my lord. I take as my point of departure now my agreement just before the short adjournment with what I understood to be my lady's suggestion that the appropriate interpretation of autocleanse is that one must apply the statute. I would respectfully adopt in that regard again Judge Ribeiro's formulation, saying that in our view the correct reading of autocleanse is that in the employment context also the ultimate question is whether the relevant statutory provisions construed purposively were intended to apply to the transaction viewed realistically. I return to that because I wanted to just say a little in that context, further to what Mr. Galbraith and Martin had said in response to my Lord Sales this morning, on the extent to which the court is entitled to assume the same parliamentary intent in framing the definition of worker in the national minimum wage legislation as under the working time regulations, where the EU characterisation of a worker must be applied. Make three short points. First, as a matter of applying well-established principles of statutory construction, different pieces of legislation should sometimes be read in what's been referred to as pari materia, and are to be construed as one, if and insofar as they deal with the same or a similar subject matter, or if, as the editors of Benyon put it, they deal with the same subject matter on similar lines. We suggest that approach is opposite to the various provisions enacting worker rights here. Secondly, we say that as a matter of reasonable inference, it is most unlikely that Parliament meant definition of worker national minimum wage legislation in 1998 and 1999 to be anything different from the definition of worker they had legislated in the 1998 working time regulations. Finally, this court has made what is referred to in one case as an equation between the definition of worker within the context of purely domestic legislation and the definition of employee in the Equality Act, which, as Miss Rose pointed out when dealing with the Mingley case, are in almost identical terms. And the latter definition is also, as with the working time regulations definition, underpinned by the same EU jurisprudence. The case I have in mind is at 1790. It's within decision of this court in the Code Plumbers, and it's in the judgment of Lord Wilson at paragraphs 14 and 15, where at 14 he first points out that the relevant definition under the Equality Act is underpinned by the EU jurisprudence such as Allenby in relation to worker. And then at 50 he says that notwithstanding murmurs of discontent in the submissions on behalf of Mr. Smith, this court is not invited to review its equation in the Bates van Wilkenhoff case of the definition of a worker in section 233 of the Act, that's the Domestic Employment Rights Act, with that of employment in section 83(2) of the Equality Act. So I think that is as far as I can take it, but it seems with respect that that's far enough. And so I would answer Lord Sales by saying that the court should indeed read all the definitions of worker in issue in this case as meaning the same thing and as therefore underpinned by the relevant EU law under the Working Time Directive. So much for our first headline submission, the correct approach as a matter of jurisprudence. Our second headline submission relates to repeated criticisms by my learned friend Miss Rose and Mr. Fraser of the tribunal in their printed case for not engaging with principles of agency law. I take issue with that. We say it is the other way round. The tribunal, who were not asked by Uber's counsel to engage with principles of agency law, applied the approach described by Lord Justice Sedley in Autoclaims, approved by this court, page 756, paragraph 36. The indented first paragraph. Employment judges have a good knowledge of the world of work and a sense derived from experience of what is real there and what is window dressing. The conclusion that Autoclaims' valeters were employees in all but name is a perfectly tenable one on the evidence which the judge had before him. The elaborate protestations in the contractual documents that the men were self-employed were odd in themselves and, when examined, bore no practical relation to the reality of the relationship. As I say, that is the approach that the tribunal in this case took. It is for Uber to demonstrate that principles of agency law vitiate that conclusion in this case. In fact, however, you may have noted there is barely a mention of those principles in Uber's printed case, and no mention at all of them by Miss Rose yesterday. What are the fundamental principles of agency law? May I invite your attention to page 1138, which is the first substantive page of the most recent edition of Bouston and Reynolds. Other than so-called canvassing agents who put their principals in touch with third parties so that they can make contracts directly with them, obviously not this case, the fundamental sine qua non of an agency is that the agent acts as a fiduciary with authority to effect his principal's legal relations with third parties. Thus, at 1001, Principle 1, agency is the fiduciary relationship which exists between two persons, one of whom expressly or impliedly manifests assent that the other should act on his behalf so as to effect his legal relations with third parties, and that 2, in respect to the acts to which the principal so assents, the agent is said to have authority to act, and this authority constitutes a power to effect the principal's legal relations with third parties. Whilst I'm in chapter 1 of Bouston, can I ask you to turn to the very bottom of page 1144? There is a heading at the very bottom of that page, control, above paragraph 1018. This is the one paragraph to which allusion, I would say, rather than citation, is made in the printed case on behalf of Uber. May I read some of that paragraph, beginning at the top of the next page? It is common to regard control by the principal as a defining characteristic of agency. Thus, restatement third defines agency in terms of acting on the principal's behalf and subject to the principal's control. This notion has obvious relevance in employment law, where it can be treated as an identifying characteristic of the employment relationship. And if we skip 4 lines to a sentence beginning at the beginning of a line, but agent, this is the sentence, or perhaps 2 sentences, to which I take Uber to have referred in their printed case. But agents will often not accept control by their principals as to the manner in which they act, and some will only accept instructions to act in accordance with usages of their own market. Others may be authorized only to do specific things. In many such situations, the principal's only control lies in his power to revoke the authority, a power which agency law assumes that he has at all times. It might seem, therefore, that control is not the significant feature of the internal relationship, except insofar as the relationship by definition posits a person, the principal, giving authority, and the agent's duty to obey instructions if he wishes to continue as agent. Nevertheless, if the principal gives up all control of his supposed agent, the relationship is only doubtfully one of agency. Summarizing that, if I may, there is no agency without the principal being able to control the agent to some extent, including to get the agent to follow his reasonable instructions. But as to the manner in which the agent carries out the agent's duties, that may unusually be reserved to the agent. I probably don't have to explain why the contracts in this case between Uber BV and the drivers do not fit that rubric for the reasons that Mr. Galbraith-Martin has elaborated this morning. But I return to the fundamental principle of agency law, and in particular in a contractual context such as the present. And if the court turns to page 1157, the court will find Article 71 at the beginning of the section contract, relations between principal and third parties. Article 71 reads, disclosed principal, general rule. A disclosed principal, whether identified or unidentified, may sue or be sued on any contract made on his behalf by his agent acting within the scope of his actual authority. And as the editors point out at the beginning of 8002, that article states the basic principle of contractual agency. As an agent acting within the scope of his actual authority, express or implied, binds and entitled his principle. It is that basic principle that is wholly undermined by the reality of the agreement between the parties in this case, as the tribunal realised. Which brings us back to the question that I suggested the CEO of Uber London might ask his lawyers. How can there be contracts between drivers and passengers if neither has any right to enforce against the other? The answer to which is they can't. Compare the secret hotels case. Even if both parties are represented by an agent in making the contract, a travel agent on behalf of the tourist and secret hotels on behalf of the hotelier, the contract is made between the tourist and the hotel. If the tourist damages the room or doesn't pay for the contents of the minibar, the hotel, the principal, can sue him for damage or loss. Secret Hotels 2 has no role to play. Conversely, if the sea view room looks out onto a car park or the air conditioning doesn't work, the tourist can obtain, via Secret Hotel, compensation from the hotel. But in this case, the notion of such a contract is, as the tribunal found, a fiction. Under no circumstance can the driver, the supposed principal, sue or be sued on the contract supposedly made on his behalf. He doesn't even know with whom that supposed contract is made. And in passing on that point, my learned friend's printed case is misleading. It is not a common feature of many contracts that parties don't know each other's identities. As to the two examples they give, in a shop, we're assuming the customer is paying in cash. The customer pays for what she purchases before leaving the shop. She has discharged her only contractual obligation. There's generally no need for her identity to be known. Though, of course, if there's a balance payable, her identity must be known. However, the seller's identity is known, and if the goods prove defective, the customer can sue the seller for the price. The second example, it may be that most taxi or minicab drivers do not ask their customers' names, but they are entitled to do so, and will certainly seek to discover the customer's name if during the journey he soils the cab and does not pay the compensation stipulated. And of course, in general, the customer does know the identity of the driver, which is generally displayed in the vehicle. In any event, there could be nothing less like an agency relationship than the present case. The driver has no rights against the passenger. Rather, Uber assumes complete control over whether and to what extent either the driver or the passenger may be compensated for damage. And however attenuated the degree of control the principal may exercise over the agent's performance of his authorised duties before the situation ceases to become one of agency, it is, to our knowledge, unprecedented and contrary to the essence of agency law that the principal in a contractual agency has no control over whether and how to enforce his rights against the third party with whom he has contracted. Looking at the documents, at 489, under the old partner terms, clause 4.3.3 provided that in case of a complaint, dispute or conflict between the partner or driver on the one hand and the customer, in this document customer means customer, passenger, on the other, or in other appropriate instances, etc., Uber may, but shall not be required to the extent permitted, etc., provide the customer, partner, the driver, and for the relevant authority, the relevant data of the partner, the driver, or the customer. Thus, Uber had a discretion but no obligation in cases of dispute to provide the identity of one party to the other. In that context, there's an interesting article by a driver about Uber's handling of an incident of racist abuse and assault by a passenger on him in 2015 when these old partner terms applied at page 515. Despite requests, many requests, Uber refused to supply to the driver the passenger's name. And at 518, 2/3 of the way down, the driver quotes in italics the agency clause in his written agreement with Uber, the one beginning for the avoidance of doubt, Uber does not itself, etc. Following which, he, in my submission, understandably comments as follows. Got that? Uber is not even a party to the contract, yet refuses to disclose to me as the principal of the contract who I am contracting with, even when I have been assaulted. And on the following page, he notes also that Uber has even refused to tell him whether it, Uber, had taken any action against the passenger. Clause 4.3.3 that I've just referred to in the old terms was symmetrical, i.e. Uber had the discretion to provide either the driver or the passenger with the other's details. Not so the new terms, which provide only for Uber's discretion to disclose the driver's contact or insurance information to the passenger and makes no provision for even the discretionary disclosure of the passenger's contact information to the driver. You go to the bottom of page 545, you'll see within clause 2.3, about 5 and a bit lines up from the bottom, the customer, now that means the driver, I'll say driver acknowledges and agrees that Uber may release the contact and or insurance information of the driver to a user upon such user's reasonable request. There's no suggestion that the driver can ever obtain the passenger's detail. Indeed, just above those words I've read out, the driver is tellingly made responsible for insuring against risks presented by acts or omissions of passengers. Why, one might wonder. And at 553, clause 7, reiterates that Uber may provide information about drivers to a third party in the event of a complaint or dispute in certain circumstances, but again, makes no provision for disclosure of information about passengers. The tribunal explored the evidence as to what happens when damage is caused by a passenger to the driver's vehicle. At the top of 370, at paragraph 27, they found that the driver's only hope of recompense was that Uber will, in some circumstances, pay drivers the cost or a contribution towards the cost of cleaning vehicles soiled by the passenger, etc., and without reference to whether Uber has received any relevant payment from the passenger, which we understand it may do at the time. Further, as the tribunal found at the bottom of 392, going on to 393, within paragraph 91, even if the passenger doesn't pay for a completed journey, it is a matter of Uber's discretion whether the driver is compensated. And if he is, it is by Uber, not because the driver has any opportunity to claim against the passenger. My lady, my lords, all this demonstrates the reality that Uber, by the terms of the agreements and by its subsequent conduct, prevents drivers from enforcing any legal right against the party within whom they are supposed to be in a contractual relationship. None of that is consistent with basic principles of agency law. As to the liability of driver to passenger at 503, at little d Roman 7, Uber gave assurances to Transport for London, recorded there, that Uber London determines and makes refunds to customers as appropriate. And as the tribunal found at page 369, paragraph 23, it does so without reference to the driver, whose payments may or may not be reduced pro rata at Uber's discretion and not pursuant to any contractual term. That, we say, is doubly inconsistent with the role of an agent. An agent, of course, as fiduciary in such a situation, would be duty-bound to ensure that it acts in its principal interests and not its own. Now, my lords, my lady, all of these matters were rightly taken into account by the tribunal at paragraphs 91 and 92 of their reasons in deciding that Uber was not acting on behalf of or working for the drivers. In this context, can I invite the court to return to the Secret Hotels 2 case at 969? It's perhaps unfortunate that the Secret Hotels 2 website no longer exists for the members of this court to access. It was a price comparison and online reservation website in respect of a certain type of hotel accommodation, mainly in the Mediterranean. Key factual features were contained within, inter alia, the website terms, which, it is important to recall, were not challenged as materially inaccurate in any way, and thus can be taken from the headnote. Just above H, on page 969, terms explain that the company, that's to say Secret Hotels 2, provides information concerning the price and availability of hotels, and that reservations you make on this site will be directly with the company whose hotel services you are booking. The company acts as agent for the hotels to provide you with information on the hotels and an online reservation service. 3 lines down at J, once the contract is made, the accommodation provider is responsible to you to provide you with what you have booked, and you are responsible to pay for it. Thus, as was said in the more general text by the Advocate General in the passages that Mr. Galbraith Martin read out to you before the shorter journey, a holidaymaker or their travel agent chooses a hotel according to its facilities and price. And once the choice is made, it is the responsibility of the hotel to provide those facilities for the price paid. The appeal in the Secret Hotels 2 case, as you know, one sees at 976 at D, turned on whether Secret Hotels 2 was a, quote, travel agent who dealt with customers in their own name or was acting solely as intermediary within the meaning of Article 306 of the relevant directive. As Lord Neuberger pointed out at 979 above E, last 3 lines of paragraph 20 of his judgment. Once the appropriate tribunal has identified and applied the relevant legal principle, it is ultimately a question of fact for that tribunal whether a travel agent falls within para 3061A or 3061B. As regards the importance of written documentation, Lord Neuberger noted the following, same page, paragraph 24. As the CJU had held in the RBS Deutschland Holdings case, it was important to bear in mind that taxable persons are generally free to choose the organisational structures and the form of transactions which they consider to be the most appropriate for their economic activities and for the purposes of limiting their tax burdens. A situation very different to that faced by the claimants in this case, where the employer dictates terms, thus requiring the purposive approach set out in auto-claims in cases where employment rights are claimed. More importantly, over the page at paragraph 29, as my learned friend has pointed out to the court, this court relied on the remarks of the CJEU in Newey. As regards in particular the importance of contractual terms, it's necessary to bear in mind the case law of the court, according to which consideration of economic and commercial realities is a fundamental criterion for the application of the common system of VAT. And that although the relevant contractual terms, bottom of the page, constitute a factor to be taken into consideration when the supplier and the recipient in a supply of services transaction has to be identified, it may become apparent that sometimes certain contractual terms do not wholly reflect the economic and commercial reality of the transactions. In particular, if it becomes apparent that those contractual terms constitute a purely artificial arrangement which does not correspond with the economic and commercial reality of the transaction. And in context, I see no meaningful difference between the phrase economic and commercial reality as applied in a VAT case to the reality of the relationship between the parties as applied in a worker or employee case. Then the court went on to consider the situation where there is a written agreement governing the obligations of the relevant parties. As has been pointed out to this court more than once, there's no written agreement governing the obligations between drivers and Uber London. And where the parties do not challenge terms of those written agreements as accurate in fact, of course, the claimants in this case have successfully challenged some of the terms of the agreements relied on by Uber as being actually inaccurate. But in that context, paragraph 34 on page 982, the court set out its final articulation of the relevant legal principles. I'll start at the top of that paragraph above C. It has never been suggested that the written agreements between MED and hoteliers, namely the accommodation agreements, were a sham. It goes on to make the same point about the website term. And then just above D, in these circumstances, it appears to me that the right starting point is to characterise the nature of the relationship between MED, the customer, and the hotel in the light of the accommodation agreement and the website terms. But one must next consider whether that characterisation can be said to represent the economic reality of the relationship in the light of any relevant facts. And that latter point is reiterated at paragraph 55 on page 987 by reference to further CJU jurisprudence just above H. It is also necessary to have regard to all the details of the case. And in that connection, the economic and commercial realities represent a fundamental criterion. A contract which does not reflect economic reality and a purely artificial arrangement is similar to the shams, rectifiable agreements, and other arrangements considered above. The approach is not identical in this case, as one would expect, to the approach in autoclaves, but nor is it wholly different. In any event, because Secret Hotels 2 is not a case in which it was alleged that the written terms were inconsistent with the reality of the relationship between the parties, it is, as the majority, and indeed as Lord Justice Underhill pointed out in that regard, of little assistance in the present case. And I do remind this court that Uber did not rely on Secret Hotels 2 before the tribunal. It is to be noted, though, that when the court in Secret Hotels 2 considered whether aspects of the way the business was run meant that SH2 acted as principal, they do that at paragraphs 45 to 50, it did find that some of the relevant matters were consistent with that analysis, that it was acting as principal. And moreover, as they put it, some of those factors were contrary to the terms of the contractual documentation. So the exercise was still conducted. They note the first such feature at page 985 at B. Number 3, MED dealt with matters of complaint and compensation in its own name and without reference to the hotelier. So it's fair to say that the court was comforted by the fact that Secret Hotels 2 apparently always recovered compensation from the hotelier. That's reflected just below G. The other factor is at 7 by E. Hoteliers would invoice MED for the net sum in respect of each customer at the end of the relevant holiday. And at paragraph 48 on the next page at B, the court noted that as to that factor, if MED was an agent, as it contends, one would have expected the hotelier's invoices to have been for the gross sum with a deduction for MED's commission. And the fact that they were for the net sum is consistent with the commission's analysis. Of course, this court nonetheless held that those factors did not, taken together or individually, negate an agency arrangement. But that does not detract at all from the principal exercise that that court was conducting, namely to determine whether there were features of the real relationship between the parties that ran contrary to the terms of the contractual documentation that might be more consistent with an analysis that Secret Hotels 2 was acting as principal. Of course, given there was no challenge to the accuracy of all the written terms, it was it's difficult for me to make the submission given that the case was decided differently until it got to the Supreme Court. But it seems, I would suggest, fairly obvious what the answer to that case should have been and in the end was. My lady, my lords, consider the proper analogue to Secret Hotels 2 in a minicab account business. The customer is offered a choice of drivers within the relevant area, each setting their own rate, showing time to pick up and offering a particular grade of vehicle. The customer picks the driver of her choice, making a contract with them directly in her own name through the app. And if the customer damages the car or fails to pay the full amount, the driver can seek compensation from it. This is a very important point. The claimants have never argued that it would not in theory be possible for a company like Uber to enter into genuine agency contracts with drivers. Nor did the tribunal hold that view. If you go to page 395, at paragraph 97, the tribunal says this: none of our reasoning should be taken as doubting that the respondents could have devised a business model not involving them employing drivers. We find only that the model which they chose fails to achieve that aim. And this is where Uber and, with respect, Lord Justice Underhill, go wrong. They proceed from the propositions that it is possible for a minicab firm to act as agent for drivers, and that is what the written agreement between the drivers and Uber BV repeatedly says is the situation, to the conclusion that the drivers are not LIMBY workers of Uber London. And that approach is doubly flawed. First and most fundamentally, it fails to address the only correct question, which, I may again borrow Judge Ribeiro's language, whether the relevant statutory provisions defining a worker, construed purposively, were intended to apply to the relationship viewed realistically. Unlike the Secret Hotels 2 case, this case does not turn on a statutory test of whether Uber dealt with customers in its own name or was acting as an intermediary. Indeed, if I may respectfully adopt Lord Reed's suggestion to Miss Rose yesterday, Uber's approach leaves out of account the purpose of the legislation. But secondly, and in any event, saying that you have created a contract of agency between Uber London and Uber's drivers, not that Uber actually ever really goes that far, is not at all the same as actually doing so. As in the Lewis Carroll poem, what I tell you 3 times is often not true. Yes, Uber might have been able to devise a business model based on contracts of agency. I've suggested the key features of such a contract by analogy with the contract in the Secret Hotels 2 case. But Uber did not, in fact, do anything of the sort. They simply took the obligations of a LIMBY worker contract and shoehorned them into something masquerading as an agency contract. Because, of course, the actual facts of the present case are wholly different to the sort of contract in Secret Hotels 2. Unlike in Secret Hotels 2, the claimants did not consent to Uber London being its agent, let alone contract with Uber London to that effect. Passengers make bookings with Uber London. Initially, the identity of the driver is not determined, yet the booking is accepted by Uber London at a price set by Uber. And in passing, we share in this regard concern at the apparent inconsistency in Uber's case, that under the statute, Uber London must accept the booking, not the driver. Yet, they argue, the driver can accept the booking through his agent. That is a legal oxymoron, we suggest. Uber London, having accepted the booking, itself finds a driver, not the customer, to provide the service that it, Uber London, has agreed to provide. The customer has no choice as to the vehicle, driver, let alone different rates. No reservation is made by the customer directly with the driver, and the driver is never told who the person is that Uber London has accepted the booking for. And if a particular driver selected by Uber London cancels or doesn't turn up, the customer has no recourse against that driver. Yes, the customer has to give Uber their credit card details in advance, but if the credit card payment doesn't go through for any reason, it is Uber who decides whether the driver bears that loss. Likewise, it is Uber who decides whether the driver will be compensated for any damage caused to his vehicle. And although these are not strong points, the 2 I'm about to mention on their own, it is also to be noted that in common with the Secret Hotels 2 case, and equally running contrary to the characterization of the relationship and the contractual documentation, those 2 factors that were noted by Lord Neuberger in that case apply a fortiori in this. Uber London deals with complaints and compensation to customers and does not always recoup compensation from drivers. And again, a fortiori, the drivers do not invoice Uber at all and are only paid the net amount. So even if one were to apply to this case the somewhat different legal approach appropriate to EU VAT law, the result would surely be the same as that reached by the tribunal in this case. Because wholly unlike Secret Hotels 2, the tribunal in this case properly found that the aspects of the documents and other evidence which ran contrary to the particular terms of the contractual documentation on which Uber relied were numerous and significant, such that to use Lord Neuberger's words quoted from paragraph 34, they considered that the characterization of the relationship in the contractual documents could not be said to represent the economic reality of the relationship in the light of those relevant facts. It is time to call a spade a spade. The truth is that the references in the written agreements between the drivers and Uber VV to Uber acting as agent for the drivers are just an extended relabeling exercise. If we combine our first two submissions, it is, we say, on analysis obvious that all the features of a Lim B dependent work relationship are present in this case, whereas none of the features of a contractual agency relationship exist in reality. And the more one engages with principles of agency law, the more obvious that becomes. So to address the issue I identified earlier, borrowing my lady's words from Bankway, the clauses in the written documentation providing for an agency relationship were not in substance or reality provisions enabling Uber to act as the driver's agent so as to alter the claimant's legal relationships with Uber's passengers and requiring Uber to act as the claimant's fiduciary in that context. They were rather provisions to enable Uber London to engage the claimants to perform work or services for it otherwise than in accordance with the statutory scheme protecting such workers. Those clauses, those relabels, made absolutely no difference to the practical and commercial reality of the relationship between the drivers and Uber London. No difference at all. That was the purpose of the hypothetical redrafting exercise I began my submissions by asking you to consider, and it was achieved. Now, naturally, that reality sometimes reveals itself in Uber's actual dealings, like original wood showing through a veneer. At page 379, for instance, the tribunal noted a message from Uber London indented into paragraph 53 in bold. We noticed you cancelled more than 15% of your jobs last week. Cancelling jobs you have accepted leads to a highly frustrating experience for riders, an unreliable experience, and lower earnings. Only accept a job if you are prepared to pick up the user and complete that job. And if you are not in a position to do work for Uber, remember, log offline at any time. Or at page 496, there is an email from Uber London to a Mr. Degama, informing him that his account has been deactivated on the ground that he is not performing at the level he would expect. And the email concludes, "We appreciate your work for Uber and wish you the best of luck in the future." Or at page 369, the guaranteed earnings scheme noted by the tribunal at paragraph 25, which, although discontinued by the time of the tribunal hearing, was in force during periods when both test claimants worked under the partner terms. So at the same period as Uber is saying, no work relationship, only agency, there was a guaranteed earnings scheme. Or at the bottom of 523, Uber's statement to Transport for London, that we would welcome any amendment to licensing conditions that ensures the names of operators' licenses reflect the trading name for consumers, in other words, Uber. This would allow consumers to identify the final entity responsible for their travel arrangements more easily. Indeed. There are several other examples in our printed case, and still others in the printed case of Hellenic Friends. It is illuminating, I suggest, to consider the broad effect of Uber's case. It would seem to accommodate any personal work arrangement where the employer provides services to customers through individual workers. Take AutoCleanse. Remember, the claimants in that case did not succeed because the written agreement included fictitious terms. They succeeded because the working relationship exhibited the obligations of a contract of service, despite the written terms saying otherwise. But what if those same obligations had been mapped onto the sort of pseudo-agency contracts in the present case? A contract between AutoCleanse and each valeter, saying that each valeter was to provide valeting services as principal to the owner of the car to be valeted, and a contract between AutoCleanse and each car owner to the same effect. Remember, Uber argues there is no limit to the control that an economically powerful agent can legitimately exercise over its principles. It also, you will recall, argues that an agency relationship per se negates worker status, let alone employee status. So presumably the valeters, if such pseudo-contracts were put into place, could then be paid less than the national minimum wage during their regular hours of work. Now, if I've misunderstood the reach of Uber's case in this regard, I will be corrected in reply, but so it seems. Finally, in the context of the effect of the supposed agency agreement, a separate point. As was pointed out by the majority of the Court of Appeal at page 274, at paragraph 82, the tribunal found there is no contract between the driver and the passenger. That is not a necessary finding in order to support a contract between Uber London and the driver at the point of acceptance by the driver. There is no analytical reason why there could not be two contracts subsisting at the same time, or rather from the time of pickup, the contract between Uber London and the driver having commenced at an earlier point of time. That is to say, the driver could undertake to Uber London to accept and carry out trips when logged on. Remember, there's no written agreement between drivers and Uber London. And he could undertake to the passenger to drive her to her destination once he picks her up. Uber London and the passenger being joint promisees in respect of driving the passenger from pickup to destination, with consideration, obviously, moving from each. That would be entirely consistent with basic principles of contract law, so basic that I'm not going to take you to them, but they are included in the bundle at page 2292 in an extract from Chitty. So even if we were wrong about there being, in reality, an implied agency relationship between Uber London and the drivers, as opposed simply to the facade of one, that does not, in fact, require this court to overturn the tribunal's finding that there was a contract whereby the drivers agreed personally to provide work or services for Uber London. And it is no answer to this point, as Ms. Rose said yesterday, to say that it was not the analysis adopted by the tribunal.
Is it possible to have a situation, sorry to interrupt.
No, please.
Is it possible to have a situation where, in fact, the putative worker is, in fact, working for two people? And how do you apply Section 54 in those circumstances? You look to see who is the predominant person for whom the work is applied.
My lady, no, because if the situation exists that I've just described, the driver would only be a LIMB worker of Uber London. The driver would not be a LIMB worker of the passenger, because as Ms. Rose pointed out in her oral submissions, that contract would be one that fell within the exclusion where the passenger is the customer or client or driver.
Yes, I was actually inquiring about a situation where the exclusion doesn't apply. I was thinking perhaps about the way in which the section works, where you have a triangular relationship, because actually the section gives you no clue about how you apply it when there is a triangular relationship. And
well, I confess, my lady, I haven't thought of a situation where you would qualify as a LIMBY worker in such a triangular relationship with both the other, you can put it, angles to the triangle. I mean, if there's one that's in your mind, I'd happily consider it. But it would seem to me, if not inevitable, certainly almost inevitable, that one of the other parties would have to be a customer or client.
Fine, let's leave it there.
Thank you. So I was saying that it's no answer to the point to say that the tribunal didn't adopt this analysis, because the tribunal analysed the relationship between the parties as a LIMBY worker relationship, namely that by reason of the obligations owed by the drivers to Uber London, they had agreed to perform work or provide services personally to Uber London for the reasons they gave. Now, Uber says that analysis cannot be right if there were contracts made between drivers and passengers. We simply reply, that's a non sequitur. There can be both. There'd be no need or point in remitting this case to the tribunal and to make further findings of fact in this context. The third related headline submission we make orally is that Uber gains no assistance from the largely unreported taxi and minicab cases in your authorities bundle. The first point to note is that in not one of the cases on which Uber has relied was the issue whether the driver was a LIMBY worker of the minicab firm. And it is well-established law, not just in this context, but as we've seen also in tax context, that one may be here an employee or worker for the purpose of one statutory provision, but not for the purpose of another. And it's not appropriate for Uber simply to read across from one statute or statutory purpose to another. Second introductory point. There are at least as many minicab cases which decided that the minicab firm contracted as a principal with its account customers as the other way round. And each decision is fact specific. Indeed, if you turn to 1132, the tax notice on which Uber relies in its printed case, in the middle of that page, 3.3, agent or principal, you look at the last paragraph there. If all your drivers are employees, you're a principal and must follow 3.2. But if your drivers are self-employed, you may, depending on the agreements you have with them, be acting as their agent for cash work and in some cases for account work as well. That rather suggests that acting as agent for account customers will be the exception rather than the rule. Those two preliminary points are not, though, to address the heart of the matter. The fact that a minicab firm can enter a genuine agency contract with its drivers gets Uber nowhere. So much was always uncontroversial. It depends on the facts in each case. I refer first to the VAT case. For the risk of repetition, we make no concession that if the issue had been LIMBY worker status, the proper conclusion in any of those cases would have been that the drivers were not workers. However, that was not the issue in those cases. There's not the time to go through each of the decisions orally. We have done so to some extent in our printed case at paragraphs 147 and following. And as those summaries indicate, there is a collection, as it were, of principal factual aspects that are relied on variously as indicating that the PHV operator acted as principal in some of those cases. And those factors are these. The operator set the fares. Customer requests were allocated to a driver by computer. The operator was responsible for collecting the whole fare from customers and bore in practice the risk of bad debt. The drivers were not entitled to 100% of the fares. The operator maintained relevant records. A certain level of control was exercised over the drivers. All of these, of course, are aspects of the present case. The closest case on its facts is probably the Bath Taxis case of 811. In that case, drivers rented a radio, giving them access to a private radio network. There was a fixed rate pricing structure set by the firm. Customer requests were allocated to a driver by a computer, and the firm was responsible for collecting the whole fare from customers and in practice bore the risk of bad debts. And the conclusion was that Bath Taxis operated as principal. Certainly, as a whole, these cases fall a long way short of demonstrating that the tribunal misdirected itself in this case, and holding that on the facts of this case, Uber was acting as principal rather than as the driver's agent. Still less does it suggest that the tribunal erred in law in concluding that the drivers were limbing workers. At the same token, the discrimination cases in which Uber relies within taxi and minicab field are, as the majority held, of no assistance to it. Mingley is at 919. It cannot be overemphasized. The only issue in Mingley was whether there was an overarching obligation, what my learned friend Mr. Galbraith Martin referred to as an umbrella contract, on the claimant to work for the respondent. You'll see from paragraph 14 that the essential facts were the claimant paid a weekly sum for a radio and access to the respondent systems, but was not obliged to work at all. If he did, he kept all the fares. The conclusion, at paragraphs 14 and 21, there was no mutuality of obligation between periods of work, and therefore no contract of employment in the sense meant under that legislation. But critically, the argument was not run in 2004 that the driver was an employee in that sense or in any other each time he was working, and there's thus no discussion in the judgment of whether the respondent was acting as principal or agent when the claimant was working. Now, in light of subsequent case law, that decision must be considered doubtful, and we referred to that subsequent case law, which is now orthodox and uncontroversial as between the three representatives in this case, at paragraph 11 of our printed case, page 186.
Is mutuality required under section 54 in our case?
Mutuality is required during the period of work, but not in the sense that one has to work a certain number of times a week or a certain number of hours a day, or to provide work a certain number of times a year or a certain number of hours a day. So the case proceeds and is decided on an issue that is completely irrelevant in this case. In any event, as the majority in the Court of Appeal pointed out, in distinguishing Mingley at paragraph 57, the facts of this case are different and more complex. The situation in Khan is even worse for Uber. Khan is at 888. In that case, the respondent conceded that the claimant was a worker. The issue was whether the claimant was an employee in the sense of working under an overarching contract of employment. Again, not whether when he worked, he did so as an employee or independent contractor. You see that at paragraph 2 and 31. Can I just summarize the essential facts? Chequers Cars had a contract with BAA to provide a taxi service, taxi rank at Gatwick. The claimant was a taxi driver at Gatwick who had complete flexibility whether and when he worked. The conclusion of the EAT was that there was no obligation to work, so the claimant was not an employee. Can I pick it up at 897 in the paragraph on which Uber relies, paragraph 32? There's a citation in inverted commas from the Hong Kong Golf Club case. And after that, EAT says, making all necessary modifications to translate the position of a caddy on a golf course to a cabbie at Gatwick. If it had been material to our decision, we would have been inclined to find that the arrangement here was analogous to that in the Hong Kong Golf Club case, as it is to that of the position in England. And on the findings of fact the tribunal made, the contract went no further than to amount to a license by Chequers to permit the claimant to offer himself as a private hire taxi driver to individual passengers. It's a little odd to find an unreported decision and an obiter observation within it in the Supreme Court bundle of authorities, but in any event, this is a very, very different set of facts. This is a taxi case. And again, there's no discussion of the company acting as agent in making contracts for the driver, any more than there was in the Hong Kong Golf Club case that the EAT cites, Cheng, in which, as you were shown yesterday, the majority of the Privy Council found that the claimant was, and I quote, merely licensed by the club to ply for hire on the golf course. The situation was similar in the Stringfellows case at 935, at paragraph 50. Third line down. Club did not employ the dancers to dance. Rather, she paid them to be provided with an opportunity to earn money by dancing for the clients. And also, my lady, you will, I'm sure, have identified that these three cases, Khan, Cheng, Ashi, are ply for hire cases. A taxi driver solicits business from travellers at Gatwick. A caddie approaches a golfer before he begins his round. A lap dancer offers to entertain a customer. In none of these cases were the facts analogous to those of the present case, and in none of them was it suggested, let alone found, that the respondent or defendant acted as the claimant's agent in making contracts on its behalf with the customer. Before leaving issue 1, we say a few words about Uber's attack on the tribunal's reasons, which concentrated very much on paragraph 91. As I've already pointed out, that paragraph exposes in part fiction of the supposed reality of an agency relationship. The driver not being able to discover the passenger's identity, the driver having no control over any aspect of his relationship with the passenger, save a very limited freedom to depart from the route set by the app at his potential cost. However, at paragraphs 92 to 95 at page 393 and following, which, and this may just have been by reason of the time allowed, but which Ms. Rose somewhat skipped over, the tribunal makes several significant findings and observations to show why it found that facts of the relationship answered the statutory description of worker. So we invite you, when you consider the tribunal's reasoning, to consider it as the tribunal expressly invited the reader to do, as a whole. And certainly paragraphs 92, which I know Mr. Galbraith Martin has made extensive reference to already, and 93 to 95 are all important in that regard. Finally, I respond quickly to the suggestion by Miss Rose that the majority in the Court of Appeal rejected a large part of the tribunal's reasoning, but concluded that it made no difference. That is unfounded. The majority disagreed with the Employment Tribunal only on the few small points identified at page 276 within paragraph 93 of the judgment on behalf of the majority. The vast majority of what the tribunal found was adopted by the majority of the Court of Appeal. Issue 2, working time. Whoever's challenge to the tribunal's conclusion on working time depends on its contention that the tribunal was not entitled to find that there were any minimal obligations on the drivers to accept and carry out journeys. Now, that contention is clearly wrong for the reasons set out by us in writing and by Mr. Galbraith Martin in particular, all of it. It is trite law under the Working Time Directive and Working Time Regulations. See, for instance, at page 2005, at paragraph 25, within the typo case, that working time is, forgive me, I've given you the wrong paragraph number. I should try and find the right paragraph number. But the point in any event.
That's 23.
23, I'm very grateful. Um, 23?
Oh, I'm sorry, 23 identifies the issue, but doesn't.
No, I don't think it's 23. I think that the point I want to make, which will at least make it easier for those who are so valiantly trying to assist me to find the right paragraph to do so, is that working time is placed in opposition to rest periods, the two being mutually exclusive. It's a quote from a paragraph on this page, but I regret to not being able to find it at the moment.
20.
In any event,
29 identifies those two concepts as being in opposition.
yes, I'm grateful. So, as I say, I don't think it's controversial, but in any event, it's well-established law, EU law and domestic law, that the two are mutually exclusive. There is no intermediate category between working time and rest. Whilst logged on, the claimants with us at Uber's disposal and therefore working as the tribunal found. Indeed, as Uber's documentation put it, they were on duty. We adopt the analysis of the Employment Appeal Tribunal on this point. I pick it up at page 361. Very top of that page, the first new sentence. There might be no requirement for a driver to stay in the territory or have the app switched on. In either event, Uber London will not offer them trips. But it cannot be said that no obligation arises at those times when they do. It is that obligation that the tribunal characterised as being available, or as Uber's onboarding welcome packet puts it, going on duty, an obligation it found essential to Uber's business. See paragraph 100. The relevant part of paragraph 100 of the tribunal's reasons is at 396. About the 10th line down, paragraph 100, beginning, it is essential to Uber's business. It is essential to Uber's business to maintain a pool of drivers who can be called on as and when a demand for driving services arises. The excellent rider experience which the organisation seeks to provide depends on its ability to get drivers to passengers as quickly as possible. To be confident of satisfying demand, it must, at any one time, have some of its drivers carrying passengers and some waiting for the opportunity to do so. Being available is an essential part of the service which the driver renders to Uber. Can I address the more than one app argument in this context? The first thing to say is that it is somewhat academic as regards these claims. Whilst there was a theoretical possibility that a driver could be logged on to more than one app simultaneously, the evidence before the tribunal was that there were no other apps during the period to which the claims relate, and the test claimants only logged on to the Uber app. However, if this court wishes to consider the then counterfactual position, where, at present or in the future, drivers may be logged on to more than one app simultaneously, again, we respectfully adopt the analysis of the Employment Appeal Tribunal, as did the majority of the Court of Appeal. Returning then to page 361, at paragraph 123, towards the bottom of that page. As for whether this would constitute working time under Reg 2 working time regs, the definition is conjunctive. All three elements, working, at his employer's disposal, carrying out his activity or duties, need to be present for the time in question to be working time. And for a purposive approach, I can see that the Uber driver, having driven to the relevant territory, although it's maybe where they live, and switched on the app, might be deemed to be working and carrying out an activity or duty being available. The question arises as to whether the driver is also at Uber London's disposal if at the same time permitted to be waiting, similarly available, for a possible assignment from another PHP operator. Whilst I have said I think the point is a difficult one, ultimately I'm persuaded that the tribunal grappled with this issue and permissibly concluded that this was not a fateful consideration in this case. The answer to the question lies again in the requirement that drivers should accept at least 80% of trip requests if paragraph 51 can be relied on, or more generally that being on duty means being willing and able to accept trip requests. The tribunal found this amounted to a requirement to accept trip. Even if the evidence allowed that drivers were not allowed to accept all trips, the high percentage of acceptances required justified the ET's conclusion that once in the territory with the app switched on, Uber drivers were available to Uber London and at its disposal. Uber complains that this finding is contradicted by the additional requirement that drivers also be able and willing to accept assignments. That language, however, is taken from Uber's own onboarding literature. The tribunal seems to have used the expression in the same way to mean that the driver is then on duty as opposed to being off duty. And I read this as the tribunal's answer to the concern that the drivers might also be workers for other fugitive employers while engaged on working time for Uber. If the drivers have entered into an obligation of the same nature for another entity, so to similarly accept almost every trip request made of them, then as a matter of evidence, they are unlikely to be at Uber's disposal. That is how I read the tribunal's observation at paragraph 122, that it will be a matter of evidence in each case whether and for how long the driver remains ready and willing to accept trips. As I say, we respectfully adopt that. Now, note in this context the document at page 572. This is one of those documents you will want to rotate on my taskbar at the top of the page. It's towards the right. There's a heading, why am I reminded to stay online? We want to be sure you're ready and able to accept a ride when you're online with Uber. If you go online with your own device and open another app before accepting a trip request, you'll see a reminder every 3 minutes to confirm your intent to stay online. So even in the period to which that document relates, 2016, Uber apparently has the means of knowing whether its drivers had another app and prompted them every 3 minutes so it could be sure you're ready and able to accept a rider when you're online with Uber. It therefore seems unlikely, on the basis of the only evidence before the tribunal, that a driver could be equally available for work on Uber's app and on another app at the same time. In any event, as pointed out in a related context, my Lady Arden noted in Walton at page 999, para 41, that whether a worker who only stands and waits is working is a question of fact, with which this tribunal cannot interfere. The Employment Tribunal stated that if it were wrong in its primary conclusion, then...
Sorry, can I ask you a question before you proceed? You're looking at this question entirely through the definition of working time, but do you also need to engage with the prior question because of whether they are workers at that time, because you're not alleging an umbrella contract, as you call it, or an overarching contract? So you have to, first of all, find that this is part of the time for which they are workers, don't you, before you get to the working time definition?
My Lord is right, but I take that to be a very easy hurdle to surmount. If they are workers, LIMB workers at all, it is because they have undertaken to perform work or services for Uber London. And when they are logged on to the app and ready and available to pick up a trip request sent to them by Uber London, I would suggest that it is obvious that that definition is met. But I agree.
When they've got another app going as well, so that would you say they've undertaken a similar obligation to the other provider?
Well, as I've said, in theory, it could be possible. It is quite possible for someone to be undertaking obligations to two people at the same time. But I hesitate to say too much more about that because there was no real evidence from the tribunal to suggest that that would happen, and certainly that it did happen. But we know that if the Uber driver has the Uber app switched on and is sent a series of trip requests, there is an obligation to accept a proportion of those requests. Now, quite what proportion remains even today in dispute between the parties, but I hesitate to say that even Uber can't properly assert. I don't believe it assert, but I would submit in any event that even Uber can't properly assert that there was no obligation on the driver to undertake a proportion of trip requests sent to the driver, because we know that if they don't undertake a proportion, they are logged off, and indeed the active can be deactivated permanently. So absolutely, my lord, if in this entirely hypothetical situation where page 572 doesn't have any effect and where there is a driver unevidenced before the tribunal who is equally under that sort of obligation to two app operators, then it may be that they will have to be in breach of an obligation to one in order to fulfill an obligation to another. In practice, however, it doesn't work that way, because what will happen if a driver has an Uber app and let's call it app X open at the same time is a trip request will come through on one and it will immediately log off the other. So I'm not sure that even the situation of being in breach will arise, but certainly the obligation persists during that period.
But that's what they would do, isn't it? And that means that on your approach, they'd be entitled to the minimum wage from each while they were available for each operator, or perhaps for free.
Well, my lord, I haven't got on to the national minimum wage legislation, but if my lord will allow, I will address that precise question in about 2 minutes. I want to just finish, if I may, briefly, the situation under the working time regulations. So what we're concerned with now is the definition of working time under those regulations, and everything that I've quoted from the AT decision thus far is an analysis on the basis of that definition. And what I was about to say was that the tribunal made an alternative finding. It said that if it was wrong in its primary conclusion that there was working time once they were logged on to the Uber app and ready and able to accept trips, then the tribunal would hold in the alternative that the working time began at the latest when the driver accepted a trip and ended when the trip was completed. They say that at paragraphs 102 and 124 for their reasons. Now, if the court were to take the view that under the working time regulations, the Employment Tribunal's primary analysis was wrong, this alternative analysis, we say, must be right. And the only reason I'm making what probably seems to you as a blindingly obvious submission is that Uber says otherwise. Uber suggests that driving time between accepting a trip and picking up a passenger is not working time. And that suggestion remains unexplained and, with respect, is clearly wrong by reference to consistent EU and domestic case law over the last 20 years. And it also just makes no sense, as the Employment Appeal Tribunal noted at page 359 at the bottom of that page, at paragraph 118. On the tribunal's findings, I see no difficulty with that conclusion in respect of periods when a driver accepts a trip from Uber London. See the alternative finding. The obligation assumed at that point is clear. The trip is assigned to that driver, and there's an expectation that they will undertake the assignment personally if substitution is not allowed, for which they will be paid at a rate laid down by Uber London, or face possible penalties if they fail to do so. It's also worth remarking in passing that Lord Justice Underhill took the same view. There is no one other than Uber's legal representatives who posit to the contrary. I now do turn to the national minimum wage legislation. For those of you who have had the joy of looking into this legislation, it is fairly complex. But the starting point in deciding whether a worker has received his entitlement under the legislation is to ascertain the hourly rate of pay paid to him in a relevant pay reference period. So, skipping to the end of the chase, you find out the hourly pay during the pay reference period. You compare that with the national minimum wage to find out whether there is underpay. 717 Regulation 7 provides that this is to be calculated by dividing the remuneration paid by the hours of work in the reference period. And at 719, at Reg 17, the rules to be applied depend on whether the work is time work, salaried hours work, output work, or unmeasured work. At 723, Reg 30 defines time work, so far as is material, as being work not salaried hours work in respect of which a worker is entitled under his contract to be paid by reference to the time worked by the worker. And in Walton, the Court of Appeal held, page 997, paragraphs 28 to 29, that payment by reference to time work means exclusively by reference to that criterion. That was not the case here, where the fares were paid, calculated by reference to time spent and distance covered and level of customer demand. I see Miss Rose has her hand up. If I could just perhaps take 30 seconds to try and answer my Lord Legate's point under this legislation, and then I will see. In relation to the 2-app point, Uber argues that the analysis of the tribunal gives rise to an anomalous result if the driver is available to work through 2 apps simultaneously. Again, I say this wasn't this case. But let us explore it. First, as we say, as a matter of fact, it is unlikely. I refer again to the evidence for the tribunal on page 572. But even if we ignore that evidence, then a driver is on duty for two employers at the same time. There must be an anomalous result. Either the driver is employed by both doing unmeasured work, or neither. And if neither, then the social policy objective of the legislation will be defeated, and the driver will be working for less than the national minimum wage, namely for nothing per hour. So we suggest that if one has to choose between those two anomalous results, it is clear which one this court should select. Apologies for running a minute or so over.
No, you're well within your time, in fact, Mr. Siegel.
I just assumed that when I saw Miss Rose's hand up that meant I was running over.
No, I think she may have been wanting to correct you on a point of information.
No, my lord, he has, in fact, that is the end of his time. I'm entitled to 35 minutes. Reply. I was originally.
Well, you had overrun, if you remember before.
I had, my lord. It was originally 45. That was why I had my hand up at that point. There was one point I did want to correct my learned friend on, which is the suggestion that if a driver had two apps switched on and accepted a trip on one, the other would automatically switch off. With respect to my learned friend, he was giving evidence at that point. There's no my instruction on that is not correct. But can I now turn to my reply and the time left to me? My Lord Reed directed the parties to the decision of this court in UBS, and in particular, we've looked at paragraphs 61 to 68 of that decision. And the key paragraph is paragraph 68, where what is said is that the facts must be analysed in the light of the statutory provision being applied. If a fact of no relevance to the application of the statute, it can be disregarded. If, on the other hand, the legislation requires the court to focus on a specific transaction, then other transactions are unlikely to have any bearing on its application. So, applying that test, the question is, what's the key fact that this statute requires the court to focus on? The key facts are the facts in Lim B, and for the purposes of this appeal, it's the first aspect of that, namely, did the claimants work under a contract by which they undertook to work or provide services for the other party to the contract? That's the question. And so the statute requires the tribunal to focus on the identification of a contract, the parties to the contract, and the terms of the contract. And critically, for this purpose, whether the contract has a particular obligation in it, an undertaking to work or provide services for the other party to the contract. For what it's worth, EU law is exactly the same. There's no material difference. And in my submission, interesting though Mr. Galbraith-Martin's excursus into EU law was, it doesn't add anything of substance to this case. And the key passage is Allenby. In the bundle, it's page 1074, paragraph 67. And you'll see that the test that's set out there is the same requirement. Is the person working for the alleged employer? Now, that explains why the focus in our submission rightly is on identifying what the real terms of the agreement are. My Lord Reed has raised a further possibility, as I understand it. What if a contract contains a genuine provision, a provision that genuinely is part of the agreement, but that provision has no commercial purpose, save to avoid worker status? Would that fall within the statutory purpose? And a good example would be where a contract does actually permit an individual to provide a substitute, doesn't require them to work personally, but where in practice that right isn't exercised. Now, If this court were to find that such a situation fell within limb B, that would be an extension of the law beyond what was stated by this court in AutoCleanse, because AutoCleanse focuses on what is the true terms of the agreement. And your lordships will recall that I showed you the passage from Lady Justice Smith that was endorsed by Lord Clark, where she drew as a distinction between a situation where there is a right that's not exercised and where on a proper analysis that right doesn't exist. That isn't the terms of the agreement. Now, of course, it's open to this court to choose to extend the law in that way, but it would be a new development. We say it wouldn't make any difference to the outcome of this appeal, because this appeal in our submission should be allowed whatever the test is to be applied. And the main reason for that is that the Employment Tribunal's conclusion that the claimants had undertaken to work for Uber London was based on a legally flawed assessment, in particular at paragraphs 90 to 93 of the tribunal decision. The tribunal held first that particular terms were inconsistent with the existence of a direct contract between the driver and passenger. In reality, we say those terms identified by the tribunal were not inconsistent with the existence of such a contract. Secondly, also at paragraph 91, the tribunal reached a number of legally erroneous conclusions about the legal consequences of a direct contract between the driver and passenger, such as in relation to insolvency. Those were also incorrect. Thirdly, as a result of those two sets of findings, the tribunal concluded at the end of paragraph 91 that the direct contract between passenger and driver was absurd and was fictitious. Now, in our submission, that conclusion, which is fundamental to the tribunal, is based on findings of fact to the effect that the tribunal assesses as inconsistent with such a contract when they were not inconsistent with it, and findings as to the legal consequences of such a contract that were flawed. Then fourthly, at paragraph 92, the tribunal erroneously concluded that control of to the extent exercised by Uber London was only consistent with the drivers working for Uber. Whereas in fact, on the case law that I've shown to the court, it was equally consistent with an agency relationship. So that the assessment that if Uber London had control, it must follow that the drivers worked for Uber was, in our submission, also erroneous. So those are all legal errors that vitiated the factual conclusion, the factual assessment that the tribunal was being asked to make about the reality of the agreement. And we say that the consequence of that, following the Jaffrey decision, is that the appeal ought to be allowed, because it is not with respect to this court to seek to pick through cherry-picked items of evidence to try to make its own factual assessment. And you had extensive submissions from both Mr. Galbraith-Martin and to a greater extent from Mr. Siegel, identifying particular sentences and saying, look, this says this shows you this or this shows you that. A lot of those statements are contentious and not accepted. I don't have time to deal with them now, but in my submission, they're not relevant to the task this court has to perform. Because the task this court has to perform is to say, well, was the finding that this tribunal made that the existence of a direct contract was fictitious and absurd correct on the basis of this tribunal's reasoning? And if not, then the matter must be remitted. Our submission is either that the only reasonable view of the facts here, or at least a potential view of the facts, was first, on the evidence, there was no undertaking by drivers to work at all, except after they had accepted a request for a trip and for the duration of the trip. Outside the period of the trip, there is no obligation on a worker to work for anybody. Secondly, in our submission, the drivers did undertake to work when they accepted a trip request, subject, of course, to the contractual right to cancel for good reason. that they did undertake the work during that period. That undertaking was made to the passenger, wasn't made to Uber London. And thirdly, in our submission, that analysis accords not only with the contracts, including both the written terms and the way they were operated, but also with the commercial reality of the situation. It was not just a device. It had consequences for Uber, and it had consequences for the drivers and also for the passengers. So firstly, no obligation to work when not driving trips. This is the finding at paragraph 92.4 of the tribunal decision that we have challenged. And it hinges, as I've shown the court, on the findings at paragraphs 51 to 53. And the court has our submission about why the reasoning there is flawed. First, the tribunal misstated the policy, but secondly, even on the policy as the tribunal recorded it, this is not an obligation to work. There is no dispute between the parties that drivers are not obliged to accept any particular trip request while they're logged on. They're always free to decline or ignore a trip request. Indeed, there's a specific button that enables them to decline a trip request. The undertaking that they've given under the services agreement is that they will log off if they are not generally available to accept trip requests for a period of time. So they don't appear on the screen as available and cause frustration to users. An obligation to switch off the app if you're not generally available to accept trips is not an obligation to work. The finding to the contrary made by this tribunal amounts to a conclusion that having the opportunity to work when you want to is to be equated with an obligation to work. We can see that in the express finding that the tribunal made at paragraph 86, the operative paragraph of its decision when it decided when it concluded they were workers. One of the three conditions that it said had to be satisfied was that they were willing and able to work. Now that, to adopt Mr. Siegel's phrase, is indeed a legal oxymoron. You cannot be under an obligation to work only when you're willing and able to work. You're not obliged to do something only when you want to do it. The extent of the obligation on the drivers is to log off. That's all. As a matter of fact, no driver's ever been deactivated for refusing trips. Now, Mr. Galbraith Martin sought to rely on a particular Twitter thread in relation to this issue. That Twitter thread was not about refusing trips. It was about cancellation after trip requests had been accepted because the driver didn't want to go to a particular destination. That's a different matter. It's about the scope of the right to cancel, but nothing to do with any obligation to accept trip requests. That's the first point. The second is the obligation to work when driving trips. And as I've said, we agree that there is such an obligation. The question is, to whom is it owed? And that is, of course, a contractual question. And that's the question that the tribunal was addressing at paragraph 91 of the judgment. You already have my submission as to why that paragraph is hopelessly flawed. It treats as absurd or fictional features of contracts that are normal and unexceptionable in general and in the private hire industry specifically. If the approach at paragraph 91 was to be applied to the many cases involving private hire operators that your lordship have in your bundles, every single one of those cases would conclude that the private hire operators were workers and were not entering into contract directly with passengers in every case for cash work and for account work. That's the position. Not because the facts of all those cases are identical to the facts of Uber's case, but because the sweeping dismissal of the standard features of such contract as absurd would render any factual distinctions immaterial. Now, that would be a pretty radical change in this industry, a radical change from the way it's operated for a very long time. But it's not a matter that the tribunal even grapples with. By the way, it was suggested that this was analogous to the account cases. In fact, the Uber situation is much closer to a cash case. These are not running accounts. Each trip is paid for immediately. It's simply that the payment mechanism operates through a secure system where the passenger has given their card details to Uber BV, and Uber BV acts as the payment agent to collect the money. That's all. But these are all actually individually paid for fares. They're not account fares. Nobody runs up a credit bill with Uber. In the same paragraph, as I've said, the tribunal misstates the legal consequences of a contract between driver and passenger, as the Court of Appeal rightly recognised at paragraph 93. But it is paragraph 91 of the tribunal's decision which leads directly to its decision at the end of that paragraph that the contract between driver and passenger can be wholly disregarded as fictional. And that conclusion in my submission cannot stand if the legal analysis of paragraph 91 is flawed in the ways that we have identified. This doesn't depend on any argument that the written terms are determinative. We've never suggested that they are. Our point is simply that the tribunal was wrong to suggest that the features of the contract at paragraph 91 were inconsistent with those written terms. It was accepted by Mr. Galbraith-Martin that the written terms were important and relevant evidence. He showed you Carmichael on that, and we agreed. But what this tribunal did was to disregard those aspects of the contract on the basis that they were fictional. And that is our complaint. Now, the Court of Appeal accepted a number of our criticisms of that paragraph, but instead latched on to the issue of the destination point. Again, the court has my submission on why that analysis is unsustainable. The driver doesn't need to know the destination before pickup because the driver's function is to drive the passenger where they want to go. If the destination were wholly unreasonable, such as being asked to drive to Cairo, no doubt that will constitute a good reason for cancellation. And there is the inconsistency that we identified between the tribunal saying this is an essential term which precludes there being a contract between driver and passenger, but doesn't think that it precludes there being a contract between Uber and passenger. So our submission is that the error of assessment at paragraph 91 is so basic that whatever you conclude is the correct legal test, the case ought to be remitted because there hasn't been proper factual assessment against proper legal principles. And we say similarly in relation to paragraph 92. Can I say it is not correct that Uber didn't refer to or run a case concerning agency before the Employment Tribunal. The key cases, as you've seen in the Employment Tribunal decision itself, were referred to, including Mingali, Quashie, and Cheng. But the tribunal proceeded on the basis that the question of whether the drivers worked for Uber depended on control. That's what they're looking at. So they're saying if there's control, it follows that the drivers work for Uber. That is an error of law. Mr. Galbraith-Martin sought to defend it by reference to the ready-mix concrete case, which is, of course, an employment contract case. And that is cited, if we can just briefly turn this up, in AutoCleanse, it's page 751. Now, this, of course, is talking about an employment contract, not a worker contract. But what he points to is the citation at paragraph 18. Contract of service exists if the following three conditions are fulfilled. One, the servant agrees that in consideration of a wage or other remuneration, he'll provide his own work and skill in the performance of some service for his master. 2, he agrees that in the performance of that service he'll be subject under control. And 3, the other provisions are not inconsistent. Now, what we're concerned with here is not the question of control, which is the second issue there. That's the question that's dealt with in relation to LIM-B contract when you ask, is the employer in the position of a customer or client or not? The issue is the first issue. Is this person undertaking to work for the other parties for contract for remuneration? That's what's referred to as the basic mutuality of obligation. So that's what the tribunal should have been assessing here, not the question of control. Now, in fact, of course, as I've shown the court, there are a number of cases in which it's been found that notwithstanding a significant degree of control, in reality, the individual was not working for the other party who had control over them, but for other third parties, and therefore didn't fall within the scope of statutory protection. That's the significance of Cheng. That's the significance of Quashie, and it's also what you find in Lord Justice Buxton's judgment in Mingley, and you find it in the taxi VAT cases too, and particularly, I'd invite you to look at Mahmood. In all of those cases, there's a high degree of control by another party who's found not to be the party for whom services are being performed. So the tribunal's basic assumption at 92.4 that if Uber London exercises control, it follows that they must be working for Uber London is false. The reality in my submission, had there been a proper assessment, which there was not, is that there is no mutuality of obligation as between the driver and Uber London. You already have my submission that there's no obligation to work for Uber London between trips, and that when the trip is happening, the obligation is owed to the passenger. There's no obligation to work for Uber London. But equally, there's no obligation to pay for any services. The driver is paid by the passenger through the agency of Uber BV. Uber London has no role in that. And there is no finding by this employment tribunal that in reality, Uber London was paying the drivers for their services. And if your lordships look at the Quashie case, which is one of the cases where there's a significantly higher degree of control, including an obligation to work, you will see that the lack of any obligation to pay is regarded as very important by Lord Justice Elias. And that's page 935, paragraph 51. Secondly, the driver, of course, is taking the commercial risk here. The substantial cost of car, fuel, separate license, insurance, and so on, which is entirely consistent with them working for themselves or working for a customer and not working for Uber London. So the commercial reality in our submission is consistent with the contractual position. The position is that drivers have a very high degree of flexibility. They can decide they don't want to work at all. If they want to work, they can work whenever they choose to do so. And there's a very low barrier to entry to the job market for them because all they need to do is to present their documents, show a basic level of English, get their driver's license, and they're off. From Uber's perspective, the forms of control that are exercised make sense commercially in terms of its protection of its commercial interest, just as they did in secret hotels too. There's no reason to infer that Uber's contracting as principal because it requires the cars to be clean, because it requires the drivers to operate proper standards and not sexually harass their passengers. If Uber drivers have a reputation for behaving in that way, Uber's business would collapse. The very point that Lord Neuberger is addressing in secret hotels too, where the Court of Appeal had held that the commercial reality of the relationship was that the website was contracting as principal, not as intermediary. So these in our submission are features that support the commercial reality of the transaction as being as the contract decides. And crucially, these central issues have never been properly assessed by the tribunal because of the way that the tribunal approached the matter at paragraphs 90 to 93. And we submit that in light of the case law and in light of the fact that the court has seen, the tribunal was wrong to approach it in that way, and this court cannot say there's only one possible right answer, and therefore the right course is to allow the appeal and remit it so that the correct test can be applied. Mr. Siegel treated the court to a slightly lurid fantasy scenario at the outset of his submissions, but that scenario can be turned on its head. What actually happened in this case is that Uber has decided to adopt a normal business model that is common in the industry in which it's operating, the private hire industry. It has adopted levels of control over the drivers that are also commonplace in that industry and that are consistent with the statutory regulatory scheme, which does not seek to impose a model of employment or worker status on those operating within it, and which are also consistent with its commercial incentives to protect its investment. It doesn't oblige its drivers to work, it doesn't pay them, it doesn't take the economic risk attendant on driving, and the remuneration that it receives is a commission payable only when the drivers drive. The question we would ask is, why is that not a commercially real agreement? And why is Uber not entitled to enshrine that arrangement in a written agreement without it being written off as a sham? It was suggested by Mr. Siegel, oh well, the employer in AutoCleanse could have just bolted on agency terms in that case. With great respect, that entirely misses the point. The point in AutoCleanse is that there's a positive finding that those individuals were under an obligation to work for AutoCleanse and that AutoCleanse was paying them to do that. And other points taken against Uber, the fact that there's no written agreement with ULL. With respect, it's hard to see how this can make a difference to the analysis. In all of the minicab cases, there are no written agreements at all. Here, there is in fact a detailed agreement for the license to use the app with UBV, in which drivers and UBV repeatedly acknowledge the role played by ULL as the local affiliate. So there is explicit agreement to ULL carrying out those functions. It's hard to see how the existence of that agreement can put Uber in a weaker position than circumstances where there are no written agreements at all. In any event, there's obviously agreement by conduct. It was suggested by Mr. Galbraith Martin that that was a new point. With respect, that's complete nonsense. Indeed, the very paragraph that he read to this court, paragraph 56.2 of our notice of appeal, makes the point that there's agreement either by the UBV agreement or by conduct, by subsequent conduct. So far as agency is concerned, a remarkable submission made by Mr. Siegel that we haven't made submissions on agency law. My lords, I found that disappointing because I thought I had made detailed submissions yesterday about the case law that showed that significant degree of control was not inconsistent with agency. And indeed, that's precisely the point on which we rely in relation to secret hotels too. That's precisely the point that Lord Neuberger is making in that case. My learned friend relies on a passage from Boosted on Agency and says that there's no control at all over the agent in this case. 2 points about that. Firstly, that's not a finding ever made by the tribunal, not surprisingly, because they never considered it properly. But secondly, it's wrong. ULL has no power to enter into any contract on behalf of the driver unless the driver has specifically consented to the individual contract by accepting the trip request. Drivers have complete control over the circumstances in which their agent can bind them in relation to third parties. My learned friend also suggested that it was impossible for drivers and passengers to enforce their contracts against each other because they didn't know their identity. With respect, that is complete nonsense. their agent knows the identities of passenger and driver. There's far greater knowledge by both parties in this case than in a typical minicab case. Typically, if you're picked up by a minicab, or even more so by a taxi driver, you have no idea who that person is unless you specifically go to the effort of asking them. But and the taxi driver or minicab driver has no idea who the identity of their passenger is. But in this case, because all passengers have had to register with Uber and have given all of their details, including their bank details, and similarly, Uber holds all the details, of course, of the drivers, both parties, if there is a dispute, are in a position to get that information. It's being held by the agent. And there is no finding by the tribunal in this case that they would have been unable to obtain that information from Uber had they sought it. With great respect, referring to an article relating to one person's experience in relation to a race discrimination claim is a prime example of the ways that Mr. Siegel has sought to persuade this court to make findings of fact that go beyond the findings of the Employment Tribunal and which are hotly contentious. And there's then the floated possibility of dual contract. A contract both with the passenger and with Uber London. That only arises on the footing that the fundamental foundation of this Employment Tribunal decision is wrong, because this tribunal found that there was no contract between driver and passenger, and there was no consideration given as to why and whether there would in those circumstances need to be an implied contract for driving services between ULL in addition to the contract with the passenger. Now, that was floated by the Court of Appeal and has been enthusiastically adopted by the respondents. In our submission, it's not a position that would be open on appeal because it would require further factual analysis. A mixed legal and factual question. And the obvious points Uber would want to take are what would be the commercial basis of the implication of such a second contract and what would be its terms. There was reference to other jurisdictions. What my learned friends didn't tell you is that there are cases going both ways. Your Lordship's having the case in the bundle of Florida case, in which the opposite conclusion was reached. And indeed, in France, more recently than the Cour de Cassation, there's been a case going the other way. But the fact that foreign courts applying different legislation on different evidence have reached different conclusions with respect is unlikely to assist your Lordships and your Ladyship on this appeal. So far as working time is concerned, I don't want to repeat the points that I made in opening. We submit that there is no basis for saying that there is any umbrella contract in this case or any worker status between trips for the reasons that I've already outlined, and that paragraph 86 is indefensible, and also that you cannot say that individuals are at the disposal of Uber when they may also simultaneously be available on other apps. And so for all those reasons, we respectfully invite the court to allow the appeal.
Thank you very much, Ms. Rose. Well, if there are no questions, I simply thank you and Mr. Galbraith-Martin and Mr. Siegel and those who have assisted you in preparing your submissions. It was obviously an important and interesting case. We'll now take time to consider the submissions and let you have our decision in due course. The court will now adjourn.